On the phone, it's a pleasure to welcome to the program James Goodale. He is the author of Fighting for the Press, the inside story of the Pentagon Papers and other battles. Welcome to the program, James.
Thank you for inviting me.
Now, before we get into sort of some of the things that you experienced during that time and their implications for now, but why write this book? We're 40 years out now from the anniversary in a couple of months, I guess. From the anniversary of the release of the Pentagon Papers. Tell us why now.
Well, why now? There are many lessons in this book for all of us, but particularly for Obama. And the principal lesson, without getting into too much detail, is don't believe them when they tell you it's going to damage national security. And number two, if you're President of the United States, don't get tied too closely to defending national security at every turn, because it will upend you. And I would argue that Obama hasn't learned the lessons, and he's all bogged down with a whole series of leaks, which if he'd read my book, he wouldn't be.
Well, all right, let's start. First, who is the them when you say don't listen to them?
Well, the them are, how do we describe it? It would be the bureaucracy, the national defense establishment. The national defense establishment is there before you're president and will be in office after you're president. And that national defense establishment has views with respect to classification of information. And unless you listen to them carefully, they will tell you absolutely everything is classified, and any disclosure of it will damage national security. I mean, that's the lesson of the Pentagon Papers. Case after case after case are the most ridiculous examples of overclassification.
Well, what do you think? I mean, what is it that drives that that sort of, I guess, ongoing bureaucracy to seek to classify more and more and more?
Well, I think it's a confusion between trying to protect confidentiality of information and protecting secrecy of information. I think that all of us who have organizational responsibility, or at least I did, with respect to institutions, have a desire to protect confidentiality of information, and it's an appropriate desire. But it doesn't mean just because you want to protect something that's confidential that it's so secret that if someone publishes it or leaks it, they go to jail. And I don't think the them that I've talked about, the national security establishment, can tell the difference anymore, or if they ever could, between what is confidential, which they want to keep to themselves, and what is secret, for which they seek criminal punishment.
And thus, I assume is the lesson of the book that had the president read, your book, I should say, Fighting for the Press. The lesson that he would have learned, that key notion that the national security establishment will always project a level of I guess, almost a grandiosity in terms of their secrets as opposed to other secrets.
Yeah, that's correct. They would they would say that everything is secret. I'll give you an example from my book. The Pentagon Papers contained speeches of President Eisenhower and President Kennedy, and they were classified. And the judge asked the person who was responsible for the classification, does that mean that they can't be released? Answer, no, they can't be released. They're classified. So you get a mindset that lacks rationality, and it's easy to pass that on to a new boy. That's the new president. And this one, President Obama, has not served in the military. And I think that he's overimpressed with that type of thinking.
Interesting. All right, so let's talk a little bit about your specific experience at the Times. I mean, when Tell us about how you first came to hear of the papers, what they represented to you, and what you actually did. What was the mechanism at that point once you were made aware of them?
Well, you got to work at a newspaper to appreciate the fact that when you're at a public event, which I was, and the managing editor or key editor says to you, "Hey, we got some classified papers," then turns on his heel and walks away, to understand he's telling you, go figure out the law, which is the way it happened. And I went and looked up the law, and there wasn't any law, and there isn't any law today, even though you wouldn't know it by reading the paper. It's been made up over the last X years. So you go look up the law. I concluded the law didn't exist, and that under the First Amendment, one should be published. So that was the first step, and then the second step is clearing it with the people who own the organization, the owners of the New York Times. They're outside lawyers, and in my case, they're running up against a stone wall. And so part of the book is describing how I moved that stone wall and the drama that resulted from it, because the Pentagon Papers case, just to remind your viewers, was this amazing case that started one day and ended one day in June, and ended on 17 days later in the Supreme Court. So that's about as best I can do as a short answer to what is really a long question.
Well, I mean, so when you say the law, I mean, what you're talking about is any type of law that speaks to the, I guess, the liability of a publishing enterprise for publishing secrets. I mean, or classified documents.
Yeah, that's right. So what you do is, if you're a lawyer, you have that sort of little nudge at a public event, you look up the law leaks. And so I looked up law leaks. Well, there wasn't any law there that either said what the liability was for the leaker, or, as you point out, the newspaper, the New York Times, which is a leakee. You look up the law, and then there was nothing there. So that really surprised me, and I began to realize it shouldn't be too much of a surprise, because we do have a First Amendment in this country, which permits people to speak and write pretty much as they please, and that the First Amendment got in the way of Congress passing any such a law.
And so now, at that point, you look up the law to see what the liability is of the New York Times as a leaky, as you call them, and between that time and you begin to make this case internally as to the right of the New York Times to publish this material. At what point did you actually see the material? And what impact did it have on you? Because part of what I know is part of this story is that your background was such, having a background in intelligence allowed you to see what this material was in terms of its potential danger to the national security of the United States.
Right. Well, this material is similar to to a lot of other intelligence material. It was rolled into my office in supermarket baskets, those things you roll on the floor, 47 volumes. I opened the first volume, and I started reading it, and I said, gee, I think I've heard this before. I flipped to the footnotes, and the material that I was reading had been published in the New York Times before, and I said, oh, zingo, because I had served for a period of time for 6 years in the Intelligence Reserve, actually writing sort of, practice papers, very much like the Pentagon Papers. So I knew what the mindset was. You go and look to the material that's already been published, you reform it, and then you put a classified stamp on it. It's classified. And I said, holy moly, I thought I was just practicing. I didn't know they really did this in real life, but there it was. The government had done just what I had done, sort of as a practice reservist. So I said, oh, this is a bunch of baloney. You can't take something that's already been published, say it again your own way, and stamp classified on it. If you want to do that, to go back to my first point, to keep things confidential, be my guest. But don't think that your view of confidentiality is going to stop me from talking to someone on the radio as I am now, or putting it in the newspaper.
And of course that wasn't. I mean, all of and we're talking thousands of pages of documents, obviously, but that was not necessarily indicative of all the information in the Pentagon Papers.
No, it wasn't indicative. I mean, the sources of information change, but you have to start somewhere. So if for example, you can reprint what you've already printed. That is to say, they say the New York Times said, top secret, I don't care what they say, I can print that. Then you move along and you get the documents that look more like what Snowden has released. Documents that instruct people how to do this and do that. And there the judgment becomes more difficult, because you have to make a common sense judgment whether the release of that information is going to damage national security. But lo and behold, and this is even true in Snowden's case, by the way, when you start researching some of the documents that look scary, you find that there have been books written about parts of them, so forth and so on. In Snowden's case, the Snowden's material had actually been released previously in the New York Times, not in great detail. But there becomes a point in which you wonder whether there are any, quotes, secrets that are going to damage, or whether we're just looking at confidentially. But if your point is it gets more difficult when you stop leaving the reprinting of the New York Times, it becomes more difficult, but not impossible.
And so when internally you had made the argument that the Times is within its rights to publish this material, it goes ahead to begin the process of publishing it. By that I mean the presses are rolling. At that point, the Nixon administration files an injunction. And what then became their legal, charge or rationale in terms of that injunction, and how does that play into the Espionage Act? And was that the first time that act had been invoked, or I should say, within, I guess, the modern era, if you will, was that the first time that had been invoked?
Yeah. Well, we hear today about the Espionage Act, and we hear that Snowden may be a spy and not a patriot. And the reason we hear that today was because way back then, for the very first time, the government decided to use the Espionage Act to stop a publication. And I had looked at that act and decided it didn't apply, because guess what? It applies to espionage. It doesn't apply to publishing in a newspaper. Espionage is when you go directly with the information and you give it to the enemy with the intent to damage the United States. That's not what happens when people publish. So the government used this law, which they found. I mean, it was the first time anyone had found it. It was the 1917 law, and I thought it was ridiculous. So when I saw the government coming in and using it after I had reached that earlier decision, I said, well, they're just up the creek on this one. The court isn't going to pay any attention to them, which was true. The court did not. So the issue became, if there's no law, we're back to that First Amendment. So their case, after they were told they couldn't use the Espionage Act, really became a case that says, okay, First Amendment says you can publish, but you can't publish material that damages national security. Yeah, that's our injunction. And that's how they got to the Supreme Court, with the New York Times enjoined, by the way, and the Washington Post, which had published more or less the same time, was not. So that was the issue before the Supreme Court.
And that case was New York Times Company versus United States, and that it was a 6-3 decision. Just tell us, I mean, what that just characterize that decision for us and what its implications should be today, because I want to move into where we are today with this stuff.
Okay, so what the decision said, look, under the First Amendment, you can't come in here and ask to stop the presses, because if you stop the presses, they can't speak. The First Amendment says you can speak. There is an exception. If the material you're talking about, government, is going to really damage national security in an immediate, horrible way, we will stop the presses. But that's going to be a very rare example, and it's certainly not in the Pentagon Papers. So in the real world, the case says, the First Amendment says, you can't stop people from publishing unless you're publishing the atomic secret during Second World War, that sort of stuff. But in the real world, you got to pass. Now, when we think about today, we're thinking about the internet age, and material gets published quickly. So the issue becomes, can you get punishment of WikiLeaks, the New York Times, anything that's on the net after it's been published, and whether that very same First Amendment protects you. And that's the area that is a little unknown, because the digital age is so new. But you got to realize, with material that goes out so fast digitally, you can't move to stop it very effectively, the way you did years ago when you just had newspapers. So the digital age has made the whole issue more relevant. We get more leaks, and for me, it's all very exciting, because in a sense, I'm reliving what's in that book with everything that happens today.